All right. Craig has over 30 years of trust administration experience and expertise in developing, implementing, and administering estate and financial plans for ultra high net worth individuals. So let's welcome Craig Hinton. So as I mentioned tonight, we're going to be covering an array of information, essentially principles on starting an estate plan. We'll get into some more challenging topics regarding estate planning. Do keep in mind that we are recording this, so if you miss something, we're going to be giving you a website that you can go back and re-listen to this if you need to. So as we get started, I may need somebody to do this right here. If you don't mind, Nita, or maybe Siri can. So here's our agenda for the night. We're gonna get you started on some modest tools. We're gonna get into some discussion with our expert panel here, learn some of the basics, find out what happens if we don't have an estate plan, and then starting to understand putting a process together. And we've kind of simplified it with a 6-step process for estate planning that we'll get into a little bit later on. We'll have plenty of time for questions. We're going to go ahead and take questions during the presentation, and just to kind of keep the presentation going, I'll probably cut things off, and then we'll be having a greater question and answer time at the end. So let's go ahead and get into it. So some of you may have received a green sheet. I'm glad you told me the color. Which was essentially a quiz, just to kind of get an idea of where people are with their estate planning documents. We did the same thing last week for financial planning. You'll notice there's some similar topics in there. But I would encourage you just to go through that, test yourself, and see how you do. You know, if your score is low, I think that's pretty telling that you probably need to make sure you stay awake in this presentation and maybe take some notes, maybe follow up with one of our expert panelists. So over here, we'll show you how the score is shaped out. So if your score came in between 16 and 20, that means that you're financially astute. So you've done some planning, you're on the right track. 11, 15, we have some concerns there, maybe some specific things that you might want to address. 6 to 10, you're not current on your finances. We're not judging here. We're just letting you know some things that probably are going to be more important to you. And then under 6, let's be real here. Okay, there's some work still to be done. So let's go ahead and look at some of the alarming data. I know this is always it's always interesting to see some of these statistics. So these are some of the statistics that we shared last week. If you notice, a lot of them are related to retirement planning. You notice there's a very high number of individuals that are living throughout our country solely on Social Security. If you live in Monterey, I don't even know how that's possible. I mean, you really can't. I have a feeling I know, but most of those residents, are probably living out of their cars or living, on the streets. But it's an alarming number. If you look at how many people have actually done an estate plan, the number's around 120 million. That means that about half the population, adult population, has no plan. So as Ralph mentioned, think about your family, thinking about the legacy that you're leaving behind to family members when you're no longer here. So Sherry, I don't know if you want to comment on any of these statistics. I thought they were kind of interesting.
Yeah, I think they're interesting and scary. And I want to thank all of you for being here tonight, because I know it takes courage to come here and to look at this subject. And many of us get very superstitious that if we think about doing an estate plan, then we think we're going to die. But clearly we're not. And so we thank you for having the courage to be here. I think it is an interesting fact is that most Americans who reach age 70 are almost out of money. And to me, that's really scary, not just for completing our lives and getting through our retirement and to the end of our lives, but the piece that really concerns me is if we become critically ill and we need long-term care. How do we then come up with the monies to pay for that? Just a couple of comments about that. Somebody who was born last year has the potential of living to be age 120. So if we're thinking about getting to the end of our lives, maybe somewhere in our 90s, can you imagine going that long and then adding to that the need for long-term care? Most of us say that when we need long-term care that we like to be at home. We like to have nursing care 24 hours a day, 7 days a week. I want you to know that costs $20,000 a month. So when we're talking about these figures, they do become very real when we are at our most vulnerable time in life.
Wow, thank you. Appreciate you sharing that.
I'll bet.
Yeah, some of those. We're gonna have fun tonight.
Yeah.
Okay, why don't we go on to the next one? So, why don't we talk about the worst case scenario? Let's look at what happens, and I'm going to ask Craig to comment on this. But let's find out what happens if you don't have an estate plan.
Well, first of all, let me say that we're at a disadvantage up here, and maybe you are as well, from the standpoint of it's 6:20, you've had a little food to eat, it's warm in the room, and our job is to keep you awake. So we will try and do our best there. If you don't have an estate plan, you really don't have that much to worry about, because the state of California has one for you. The question are your objectives and goals in concert with those of the state of California? I think most of us would say no, they're not. And so it's important to take a look at making sure that, first of all, you have an estate plan, which we're going to cover tonight. And it's important to also take a look at some of the issues if you don't have a plan, or if your plan is not up to date. So in a situation where your documents are not up to date, maybe it's a situation where you created your estate plan 15 years ago and you were very happy with the fact that it was taken care of, and you haven't looked at it since. So it's important to continually update the plan, and it can come down to the real basics of life. For instance, if your plan is not up to date and a death occurs, very basic things such as what are your wishes as far as funeral instructions? Those types of instructions can be found in a document or a letter of instruction that you would leave. It can also be found perhaps in a durable power of attorney for health care. Instructions can also be a part of your will. So there are various places where those instructions can be left, but if no one knows where they are, it creates a difficult situation. And throughout my 35-plus year career, there have been those situations where just memorial services or basic funeral instructions were not followed because the information was not available. So it gets down to the real basics there. Also, if your plan is not up to date, you can have difficulties, or your executor can have difficulties even having an executor appointed by the court. If you have minor children, within your will, you typically will name a guardian for minor children. If your will is not available, then there are going to be issues where perhaps the court may appoint a guardian for minor children that would not be in accordance with your instructions. And so it gets down to the very basics of where we live. Money may go too soon to children. We're probably aware that in the event that one of the beneficiaries of your estate is under age 18, funds can't be distributed directly to that individual. They would be going into some sort of a blocked account and control for the benefit of that child. And then when the child turns age 18, funds are distributed out to them. Now, I don't know about you, but I have two sons that are currently 24 and 22. When my sons turned age 18, I really wouldn't feel comfortable with them receiving a considerable sum of money. At age 18, maybe anything over about $12 was too much for them. And so there are ways that you can certainly, one, structure your estate plan to take care of minor children from the standpoint of making sure that there's a proper guardian appointed. But you can also avoid a situation where funds would be distributed to them at such an early age. And Eric will go into some of those planning techniques a little later. One of the other issues, though, as it relates to not having your plan up to date, but if your assets are not titled properly, or if the beneficiary designation on your retirement plans or insurance policies is not correct, that can create some real issues as well. For instance, in this section, I think the most important thing to remember is that how you hold title on your property it takes a higher priority than the terms set forth in your will. Let me repeat that. How you hold title to your property takes a higher priority than your will. Now you say, well, what does that mean, or how can that function? Let's say, take the example of let's say, mountain cabin and property that you inherited from your parents upon their passing. You and your brother inherited the property, and you thought, okay, we're going to use this property. One brother leaves, goes to Michigan, and hasn't been back in the state in the last 18 years. And basically tells his brother here, you know what, I'm not going to use the property, you do what you want to with it. So the brother decides, all right, gosh, I think I want to give that property to my church. Or I want to give that property to the library, so that it would be a great retreat or a camp for kids. And I really feel compelled to do that. So in his will, he says, I'm going to leave this to the library. Well, upon his passing, the executor starts working with the estate settlement process and finds that, gosh, that's a very nice thought, but the property is still held as joint tenants with right of survivorship between the two brothers. And so guess what? The library is out of the picture. Brother in Michigan receives the property. And that's because that's how the property was titled. There may be some of us in the room that have gone through what I fondly refer to as a domestic transition. And I find that maybe I have a former spouse. It's all hypothetical. But over the years, I've remarried, and everything is well and good. But upon my death, what happens if I find that, gosh, I neglected to change the beneficiary designation on an insurance policy or on a retirement plan? But in my will or in my trust, it says I want everything to go to my spouse. I want everything to go into a trust. It's going back to that beneficiary designation. And my former spouse is very happy about that. I'm sure not pleased that I'm gone, but she is going to receive the insurance proceeds as opposed to my current spouse. And so I think it's really important to understand that, one, it's important to have an estate plan. You need to have your documents up to date. But you have to make sure, and I'm sure that Eric will go into this a little bit more later, you have to make sure that you properly transfer legal title on those assets in such a form that's going to make sure that they're going to be distributed and handled in the way that you want. I think that's it for the time.
Okay. All right. Thank you, Craig. I appreciate that. I think that's a great lead into Eric. I'm sure you have some thoughts on, or maybe you can just explain the process of how things get distributed if it's decided by the court system.
If you don't have a will, Who's going to get your estate when you die? Do you have any idea? Do you know what the default plan is at the state of California level? A lot of people tell me, oh, well, I guess it goes to the state. Well, that's not true. The state doesn't get it unless there's nobody left in your family. But if you are married and you had children and you die without a will, it makes a difference what kind of property you have and who survives you. There's community property between spouses, but spouses can also have separate property that belongs to one or the other of them alone. Well, the default plan is that if you die with no will in California, all of your community property will go to your surviving spouse. Your separate property gets divided between your surviving spouse and your children. And how much they get depends on how many children you have. If you have only one child, the child gets half of the separate property and the spouse gets the other half of the separate property. If you have 2 or more children, your children get 2/3 of your separate property. Your spouse gets 1/3. Yeah, it may sound okay as a default plan, but when you start thinking about things, a lot of people have fairly valuable assets like a piece of real estate that's titled in one spouse's name only. And you can see what's going to happen if that person dies with no will. If it's their separate property, who's going to get it when they die? 1/3 will go to the spouse, 2/3 will go to the children, regardless of how old they are. Now, that starts to create complications of its own. But, you know, that's the default rules. Now, what happens if you don't have a spouse or children? Ooh, that's an interesting dilemma. Well, then they start going back up through your family tree to see where there's a branch with somebody still living on it. Okay, they'll go up to your parents. If they're still alive, that's where it stops. They would inherit from you. If they're not around, but you have surviving brothers, sisters, or nieces or nephews, they're going to be the ones to inherit from you by the default plan. And it just keeps going like that. I've got a situation right now where I'm helping to probate an estate for a woman who died without a will. Her estate is going to 4 cousins, 4 first cousins, one of whom she can't stand and didn't want anything to do with. Okay, but we're having to deal with it because that's who her lack of planning is going to make her heirs. So that's something to be very careful about. I would really strongly encourage you to have at least a will. If you own more than $150,000 worth of assets in this state, it's a real good idea to have a living trust. The cost of probate is one of the biggest disincentives to just having your assets passed by will. We'll talk more about that in a little bit, but wanted to bring it up. You know, if you've got a taxable estate, you have to deal with the fact that there may be some estate taxes that have to be paid by someone out of your assets. I'm not going to ask for a show of hands, but you know, I'm wondering how many of you know what is the exemption from estate tax this year? Okay.
What did you
Oh,
say? 5 million.
somebody was close back there. They said 5.45. That was last year's. 5.49 million is the exemption for 2017. It's been gradually going up since 2010, and Congress keeps changing the rules about the estate taxes and that sort of thing. But it's important to know whether you have a taxable estate or not, and if you do, what planning are you going to do to try to minimize the estate tax implications for your estate? There's a state tax that you might have to deal with too, depending on what state you live in. California, fortunately for us who live here, does not have a death tax or an estate tax anymore. That was done away with quite a few years ago. It will take a 2/3 majority of the voters in the state to bring it back, and I don't think that's going to happen. But there are other states out there that do have state death taxes on top of the federal estate tax. And there's some states that still have what they call inheritance taxes. California does not have an inheritance tax. So in California, we only really worry about the federal estate tax and that number that keeps changing every year. But if you're well below 5 million, you're fairly safe, and you don't have to worry about that aspect of taxation at least. There's only 6 states out there that do inheritance taxes now. Let's see. A couple of pointers, things that you might want to be aware of. What about adopted children or foster children or stepchildren? That's a question that comes up for a lot of blended families these days and others. An adopted child, if they're legally adopted, they inherit from you just the same as a natural born child. Okay? So that's something to be aware of. Foster children do not, unless you name them specifically. So if you have a foster child that you want to leave part of your estate to, you have to make a point of naming them specifically. You can't just say, I leave my estate to my children. Likewise, with stepchildren, normally they are not included in the default plan that the state has. They are not intestate beneficiaries, if you will. Intestate is a word that means dying without a will. The stepchildren that you have, if you want to include them, you do need to name them. Okay? Likewise, a lot of people are thinking about their children's spouses and where that's going to fit into the whole picture. Well, unless you specifically make a point of including them, normally they will not be considered to be beneficiaries of your estate by default. That doesn't happen automatically. That only happens if you make them a beneficiary. And the big one that I want to mention to you is you can't leave anything to friends or to charity unless you do a will or a trust, or you designate them somehow as a beneficiary on a life insurance policy or a retirement account. If you want to include somebody outside your family, you need to be very deliberate and intentional about it. You need to put it in writing. You know, a lot of people would like very much to include a charity as part of their legacy plan. And if you're interested in that and you want more information, any of us would be happy to talk to you. But that's something I want to encourage you to think about, because that's what builds this country's future, is what we leave behind as a legacy for places like the Monterey Public Library that are going to do good things for us and our families for the rest of our lives.
That's great, Eric. I appreciate you sharing all that. I think it's important to also look into how it's actually done. So maybe we can spend some time just looking at what the specific documents are. Maybe get comfortable with some of the terms that are being used already, just so we can get a better understanding of the differences between what's a will, what's a trust, what's a power of attorney. So if you wouldn't mind just spending a couple minutes just going through those, just so we can get folks familiar with those terms as we go on.
Excellent. I'm going to go through it in kind of a fairly just brief summary fashion. A will is a document where you can leave what you want to the people you want it to go to, and in the manner and at the time that you want it to go to them. Wills don't become effective until the person who wrote the will dies. While the will is just sitting in your drawer, it's an inactive document. It doesn't have any legal consequence other than when you pass away. It becomes activated at that point. Wills normally have to go through a process called probate. Probate in California is a legal proceeding that involves the courts. It generally takes the better part of a year, and it ties up the assets for most of that time. People don't just get things distributed to them right away after someone dies, if they're getting assets by will. There's a pink sheet out on the table out there called the cost of probate, if you're really interested in this. Probate costs are associated with statutory fees that are paid both to the executor for the will and the attorney for the estate. And these are kind of expensive, frankly. I mean, if you just had an estate worth $500,000, the statutory fee on that is $13,000, payable both to the executor and the attorney, if they take their full fee. And if you have a $500,000 house with a $450,000 mortgage on it, and that's your sole asset, well, I hate to break it to you, but they go on the gross value, not the net equity value, to determine the statutory fees. So there's some compelling reasons to think maybe probate might be worth avoiding. You do have an executor appointed by will. That is a person who essentially administers the estate. They take care of making sure all of the creditors are located and paid. They make sure that your taxes are filed and paid. They make sure that the assets that are out there that belong in the estate are identified and rounded up, and that the people who are supposed to receive them actually do. And that is all supervised by the court system. So there are some protections there. If you have a revocable living trust, you don't have to go through probate. If the assets are properly funded and titled in the name of the trust, you won't have to deal with probate. Yeah, question?
Is that executor someone court-appointed, like a third party, or is it someone in your family?
Is the executor a court-appointed person or someone in your family? Well, it could be either, actually. Normally, the executor is someone nominated in the will. And as long as that person's willing to act and is available, they would typically be appointed by the court. But if there's no one named, or if there's no will, the court will nominate and appoint an administrator who will be the equivalent of the executor. Yes, sir?
If you have a trust, you still need the will?
If you have a trust, do you still need the will? That's a really good question, and the answer is, I think so. Why? A couple of reasons. Number one, if you have minor children, the will is where you want to nominate guardians for those minor children in case the parents are ever killed before the kids get to be adults. That's the best place to do it. Also, I think that having a will with a trust acts as sort of a safety net, because if there's anything you forgot to put in your trust, and you find out after, well, the family finds out after you're gone that this is sitting here outside the trust and it's not in the trust, well, a pour-over will functions to leave to the trust any assets that aren't there already. As long as the value of what you're having go through the will into the trust is less than $150,000, you won't have to go through probate. There's an abbreviated procedure for that. Yes, ma'am?
What if there is a contradictory information in will and the trust? What prevails?
Oh, gosh. Contradictory information in the will and the trust. Well, if the will is not admitted to probate, the trust will prevail, because the will is just a document that's there in case it's needed. I don't see that come up very much. Yes, ma'am?
I need to go back a few steps. If you do have a will, must you all go into probate, or is probate always, does it always take place?
Does probate always take place when you have a will? The answer is no. It depends on the assets and how they're titled. Like Craig was mentioning, how things are titled is critical. If you have assets held in joint tenancy and the joint tenant person survives you, that asset goes to them. Doesn't pass through your will, doesn't go through probate. If you have assets that have designated beneficiaries, like life insurance or annuities or retirement accounts, those will pass to the designated beneficiaries who survive you, and they will not go through probate. So it's entirely possible to get your estate whittled down to a non-probate amount by dealing with other ways of property titling or beneficiary designations. But that's something you should work with a qualified advisor to help you plan that out. Want to talk a little bit more about trusts as opposed to wills. A trust, you can do anything with a trust that you could do with a will. You can determine who's going to get what, when, how much. There's really no limitations to trusts versus wills in that regard. We're going to talk a little bit more about revocable versus irrevocable trusts and living versus testamentary trusts. I don't want to overwhelm you with too much vocabulary and new terms, but that's coming. We'll cover that.
Would you just comment maybe a little bit just on powers of attorney, the differences between a
just
durable
gonna
and a
do that.
healthcare directive?
Yeah. When we do living trusts or wills or either one actually, the standard of practice in the legal community is also to encourage the client to do what Chris just said, a durable power of attorney and a healthcare directive. A durable power of attorney is a document that allows you to name someone who will act as your agent in the event that you're absent or incapacitated for a period. The folks in the military use these all the time because people are one spouse overseas and one spouse here, and you need a power of attorney to help the local spouse deal with the family matters. And I think it's a wonderful tool to help guard against the need for a conservatorship if you ever did become incapacitated. If you've got a power of attorney in place, you may not need to have to go the course of getting a conservatorship set up. And along with the power of attorney, we recommend an advanced healthcare directive. That's a document that allows you to designate an agent who has the legal authority to make healthcare decisions for you in the event that you're not able to make them yourself, but they have a guide. They have your instructions. They know what you want in certain situations, and they will have the legal authority to see that your wishes are followed. We'll talk more about that too.
Question?
Yes, yes, sir.
How durable is a durable power of attorney? Does it, okay.
That's a good question. How durable is a durable power of attorney? Well, if it contains the word durable, what that means is that it continues to be in effect even if you subsequently become incapacitated. If you have a non-durable power of attorney, your incapacity voids the document. That's why you generally want to have a durable one, because part of what you're doing it for is incapacity. Okay, I can't understand why people do it the other way.
It doesn't survive the death. Right?
No, thank you. Yes, it does not survive the death. The power of attorney terminates when the creator of the power of attorney passes away.
Can you also comment on when it goes into effect?
A power of attorney, there's two kinds. There's springing powers of attorney, which only become effective when you're incapacitated. And then there are immediate powers of attorney, which are immediate as soon as you sign it. It's up and running and good to go. The springing durable power of attorney may seem like it's the safer way to go because you haven't really given any authority to anyone until the need actually arises, and it may never arise. But you have to have a mechanism built into the document for how will your incapacity be determined in order to activate the power of attorney. I had a situation a few years back where one of my clients, who was 102 at the time, got to the point where he decided he didn't need to pay his bills anymore. And he just didn't want to, you know. It wasn't important to. I've seen this over and over again, folks, so it's not uncommon. Except that we had a springing power of attorney, and the only person left alive who he had named to make a decision about his incapacity was his doctor, who refused to deem him incapacitated. Yeah, a little bit of a problem there. It took us a long time to get working around that, but we finally managed to get the power of attorney activated. But it was not fun, and I because of the difficulty that we sometimes have in determining incapacity, it's not the best way to go, in my humble opinion. I've known a lot of people who were sharp as a tack in the morning, and you couldn't ask them a question and get an honest answer in the evening. The ability to maintain continual continuity as far as their capacity is concerned was all over the board. So at what point in time had they actually crossed the line into incapacity? I don't know. Anyway, I would caution you with springing durable powers of attorney. Thank you, Chris, for asking that. Yes.
So we're,
Is there, sorry.
okay. Would you mind just holding it till the end so we can move on here? Thank you. I want to move on to Sherry, because Eric just kind of scared us all with all those overwhelming terms. They're all useful and they all work together. But I think it'd be helpful just to get some comments from Sherry and her expertise on how do you take all this and really turn it into some practical steps, maybe some things to consider as we look at our own situations and the estate planning that we need to do.